Well, good morning, everybody. I hope you're all bright and chipper this morning. I know a good number of you were over at Lima last night. I think there were a lot of people who held out quite a bit longer than I did. So, testament to your fortitude. And I hope you are ready to go once again with a very stimulating and interesting conversation on a very important topic. As we all know, this is the bugaboo. I love that word, especially when Judge Kaczynski says it. The bugaboo of the progressive community, Citizens United. And we certainly heard a little bit about it from Justice Ginsburg last night. So a lot of food for thought. And this morning, we are going to have a panel moderated by a wonderful moderator, Michael Tomasky, who's the editor-in-chief of Democracy, a progressive journal of ideas. Michael is also a special correspondent for Newsweek and the Daily Beast, contributing editor for the American Prospect, and a contributor to the New York Review of Books. He's also the author of Left for Dead, The Life, Death, and Possible Resurrection of Progressive Politics in America. I'd like to say probable, hopeful. Yeah.
I wrote that 15 years ago.
Okay, so
still waiting.
Still waiting. There's still hope. And you guys are there. You are our hope. And Michael also wrote Hillary's Turn, Inside Her Improbable Victorious Senate Campaign, a chronicle of Hillary Clinton's successful election to the U.S. Senate in 2000. So we are particularly honored to have a great moderator this morning, so please join me in welcoming Michael Tomasky.
Caroline, thank you so much. I'm really, really thrilled to be doing this, and I'm looking forward to hearing what all these folks have to say, as much as all of you are. And I won't waste very much time, but I do have a couple of housekeeping announcements that I've been told to make. CLE. Please advise the audience, I am told, that this session has been approved for CLE credit. All those interested in obtaining credit should. First, sign on in the attendance record at the CLE table outside of this room. I saw it as I walked in. I can vouch that it's there. At the beginning of the session, pick up a certificate of attendance, and finally fill out an evaluation form and submit it to the CLE table at the end of the panel discussion. Doesn't sound very complicated. If you do not sign in, you won't receive the credit you are due for this session. Now, I have some things to say at the end about breakout panels that will happen later, but let's start right in and get moving. I don't feel that I need to make dramatic introductory remarks because I think everyone in this room understands the Citizens United decision, the whole legal trajectory of which it is a part, the consequences, the ramifications, and the importance, etc. And that's why we have these 6 distinguished people here anyway, to tell us more about that. So we're just going to start. We're going to go, not exactly down the row, but 1 through 6. And we're going to give everyone 4 minutes to make kind of an opening statement in response to a very general question from me. Young Ryan here, all of you, all 6 of you, Fred, please look at young Ryan here. See that sign that says stop?
Stop. Is there an enforcement system?
There is no go sign. There's only a stop sign. We're going to start, of course, with Fred Wertheimer, the founder and president of Democracy 21. Fred, if you will give us a quick lay of the land and how you see things right now.
Well, I want to start with the perspective of an individual who actually predates the Watergate scandals. And this is what he said. The abuse of buying and selling votes crept in, and money began to play an important part in determining elections. Later on, however, this process of corruption spread to the law courts and to the army, and finally, when even the sword became enslaved by the power of gold, the Republic was subject to the rule of emperors. This is Plutarch writing in the 1st century about the fall of the Roman Republic. Skipping 20 centuries, as we know, on June 17th, 40 years ago, a, quote, third-rate burglary at the Watergate began the unraveling of the worst campaign finance and political scandals of the last century. And the defining elements of the campaign finance scandals were secret money, unlimited contributions, and corporate funds. Now, that might sound familiar. There are any number of examples of the corruption that occurred. We passed campaign finance laws. Supreme Court upheld many of the parts, knocked out others. In upholding the contribution limits, the court said they were necessary to deal with the reality or appearance of corruption inherent in a system permitting unlimited financial contributions. Today, once again, we've got massive amounts of unlimited contributions, secret money, and corporate funds flowing into federal elections. We've got the same campaign finance elements that resulted in widespread corruption in the early 1970s. A couple of examples of what's going on, and I'll get into other examples later. The super PACs that were created by the Citizens United decision and by a Court of Appeals decision explicitly based on Citizens United, courtesy of my neighbor over here, have turned out to be a political sandbox for millionaires and billionaires. For example, 32 billionaires have given contributions ranging from $50,000 to $10 million to Restore Our Future, the super PAC whose only role is to support Romney. This includes $10 million from Sheldon Adelson. He and his wife previously gave $21 million to the Gingrich super PAC, and he has indicated that he is going to give limitless amounts to Restore Our Future in the future. Here's what Judge Richard Posner said on a blog about contributions to super PACs like the one supporting both Obama and Mitt Romney. It's difficult to see what practical difference there is between super PAC donations and direct campaign donations from a corruption standpoint. A super PAC is a valuable weapon for a campaign, as the heavy expenditures of Restore Our Future, the large super PAC that supports Romney and has attacked his opponent, proves. The donors to it are known, and it is unclear why they should expect less quid pro quo from their favorite candidate if he's successful than a direct donor to the candidate's campaign. I've got a number of other, I'll give one more example. The top 50 donors to super PACs in this election have given approximately $100 million. That's 63% of all of the money given to super PACs so far, and it comes from 1% of the donors to the super PACs. 50 donors, $100 million. So the inherently corrupt system of unlimited contributions and secret money that fueled Watergate is back with a vengeance in American politics, and the new campaign finance system established, or maybe I should say enacted, by the Supreme Court.
Well played, sir, within the time limit. I want to go second to Zephyr Teachout. Zephyr is of Fordham University School of Law, and some of you may remember her with Dean for America, and she's done 100 other things. Zephyr is a specialist on the constitutional history, the history of the treatment of corporations and other aspects of this. So why don't you give us a sketch of where you approach this from?
Well, one of the things I think is really important is to think about the Constitution in relationship to what Fred was just talking about. Anyone who's spent any time reading the notes from the convention, the Constitutional Convention or the Federalist Papers, knows that at the top of mind were questions about money and politics and real concerns about corruption of this new republic. So there were a lot of reference points. One reference point was Rome, and a real anxiety that we would become like Rome if we allowed money to direct policy instead of representatives who are actually faithful to the interests of the public. Another real focal point was Britain, and the bribes, as Franklin would talk about them, the way that the king would bribe parliamentarians with offices and other perks, and distract the representatives, again, from who they should pay attention to. So there's hundreds of examples, but if you look at Federalist 57, you see Madison saying, one of the reasons that you should believe that this will be a country of the many, representing the many, instead of representing the few, is that we have a system in which the bribes of the rich cannot distract our representatives. So there are a lot of provisions, including the veto provision. There was a concern that the executive might bribe senators. The limitation on civil office holding. There are dozens of provisions within the Constitution that are directly related to this concern that we're talking about now. And so what I think is important is to understand how deeply American this fight against the real tendency, as Fred was talking about, of polities to be corrupted by money in politics. So when Madison's talking about the bribes of the rich, he's talking about somebody like Adelson saying, I'm going to spend unlimited amounts of money to get my policy as opposed to the policy of the public. Under any Madisonian, Hamiltonian, Mason vision of the Constitution, this kind of behavior is completely outside the vision. So, but you don't need to be an originalist to believe this. You see the same kind of focus on corruption and the job of both courts and Congress to fight corruption over the next 200 years. So in the 1880s, you'll see the court saying the job of a republic is to fight against violence and corruption. This is sort of a core function of what we do in a republic. And this continues until basically the last couple decades, where you see this sense that corruption is just a post-Watergate concern and just a liberal reformer concern. I don't think that there's any credible constitutional vision, whether you're an originalist or not, that, that tells a story of what the Constitution is for, what representative self-government is for, and says it's also okay for someone to come in and threaten unlimited spending unless their policy vision is pursued.
Great, thank you. Moving briskly along, I want to go next to Bradley Smith. Bradley is with Capital University School of Law and the director of the Center for Competitive Politics. He's here, as is often said, at these kind of Washington confabs to represent the other side. So we thank you for that. And well, go ahead and represent it. And let me just ask you, I mean, I'll be polite, I promise.
He's been doing pretty well so far.
Yes. Well, let me just ask, okay, the famous oft-quoted sentence from the Citizens United decision, independent expenditures, including by corporations, do not give the appearance of corruption, do not lead to corruption or give the appearance of corruption. Is that really true?
Do I get extra time on my opening to answer that?
Okay, yeah, okay. You can take the 30 seconds Zephyr didn't use.
I think what you have to realize is what the court is saying there is that it's a legal construct. It is not sufficient to override the First Amendment. In other words, they're not necessarily saying that some people won't think it's corrupting in some vague way. And note what a vague term we use, corruption. A lot of people use it simply to mean the side I like isn't winning or somebody's spending more money than someone else. And what the court is really saying there is that as a constitutional matter, that's not going to be enough to override First Amendment protections. Now, in framing this sort of different vision, I'm going to take an approach of telling a little story about Citizens United, and then I'm going to present that alternative vision of the Constitution that Professor Teachout says doesn't exist, and then I'm going to tell one more little story that's kind of a warning story. So let's start with the first story. This involves a film producer who wanted to produce a movie, kind of a hackneyed documentary, that would be very critical of a candidate who was favored for election to the presidency of the United States. So he took his corporation that made movies, it's a corporation, and he went out and he solicited money from other corporations and individuals, and then they used this to produce again, this very assertive movie in which he said the purpose of the movie, the main reason he made the movie, was to try to defeat one of the candidates for office. Now, this is, of course, the story of Michael Moore making Fahrenheit 9/11. And we got complaints about this to the FEC, which the FEC decided, essentially kind of like, I mean, Michael Moore, it's a Cannes Film Festival, for God's sake. We can't tell him he can't run a movie. So then a group called Citizens United tried to do essentially the same thing. We said, well, who ever heard of you? You haven't been at the Cannes Film Festival. And so we said, you can't air your movie. So they went out and made a whole bunch of other movies, entered them in film festivals, and came back 4 years later and said, we got a movie, we want to run it. What's the story? Okay, and that's what you have to think about. This is what Citizens United addresses. Can something be banned simply because a corporation, say Barnes & Noble, sells it or distributes it, or produces it, say TriStar or DreamWorks? Can just the mere fact that a corporation is involved be enough to limit this? To me, the radical part of the decision was that 4 Supreme Court justices said, yes, that's enough. Now, let me give you this alternative point of view. I'm going to read a little bit. It goes like this. The principle at stake is not particular unions. It is applicable as well to associations of manufacturers, retail and wholesale groups, consumers' leagues, farmers' unions, religious and other associations representing the segment of American life and taking an active part in our political campaigns and discussions. It is as important an issue as has ever come before the court, for it reaches to the very vitals of our system of government. Under the Constitution, it is we, the people, who are sovereign. The people have the final say. The legislators are their spokesmen. The people determine through their votes the destiny of the nation. It is therefore vitally important that all channels of communication be open to the people during every election, that no point of view be restrained or barred, and that the people have access to the views of every group in the community. Until today, political speech has never been considered a crime. Some may think that one group or another should not express its views in an election because it is too powerful, because it advocates unpopular ideas, or because it has a record of lawless action. But these are not justifications for withholding First Amendment rights from any group, labor or corporate. First Amendment rights are part of the heritage of all persons and groups in this country. They are not to be dispensed or withheld merely because we or the Congress thinks that a person or group is worthy or unworthy. Okay? That is Justice William O. Douglas, right, writing in United Auto Workers v. United States, a case in which the United States government was prosecuting the United Auto Workers, and as he points out, the first time in which the court suggested that you could actually make it a crime to engage in political activity. Okay? He was joined in that opinion by other icons, such as Chief Justice Warren, others who have voted, for example, to allow unlimited independent expenditures have included Justice Brennan and so on. So there is a competing view of the Constitution.
The clock is ticking here.
Let me close then with a warning story, and that is this. The first prosecution ever brought under the Federal Election Campaign Act was brought against a group of professors and professionals in New York who'd taken out a full-page ad in the New York Times, right, calling for the impeachment of Richard Nixon. And this was before Watergate. This was because of the invasion of Cambodia. And the Nixon folks said, well, if people are convinced they ought to impeach me, that might influence them to vote against me, and therefore this would seem to violate the Federal Election Campaign Act. So you need to ask yourselves in this audience, are you willing to run the possibility of a Republican Senate and a Republican House and a President Romney regulating your political speech 7 months from now? That's the alternative view.
Okay, that's a fair question. We'll come back to answering it later. To my immediate left here is Anthony Johnstone. He's with the University of Minnesota School of Law, and he is...
Montana.
Montana. What did I say?
Minnesota.
Minnesota.
I was raised in Minnesota.
Yeah.
Minnesota's great.
Oh, well, that's
I'm from Montana.
That's what I meant. No. No, we all know, of course, that Montana is in the center of this story right now in a very big way, so I apologize. And he is serving as a Special Assistant Attorney General in that great state for the case that is now before the Supreme Court. So why don't you tell us a little bit about the background of Montana and what you hope comes out of this or what you think might come out of it?
Sure. Montana's story begins more than a century ago when, even before statehood, the Treasure State attracted outside interests to exploit the vast natural resource wealth that Montana has to offer and still has to offer. Unfortunately, that exploitation ran to our democracy as well. And so the people of Montana saw this. They saw it as corruption. They called it as they saw it. And rather than looking to far-off courts or congressmen, they said enough is enough. and a group, a supermajority of miners and farmers and businessmen, a Republican newspaperman from the small town of Fort Benton, who also happens to be my great-great-grandfather, got together and said, now, wait a second. As Brad said, this is popular sovereignty here. You, our politicians in our corrupted capital, do not govern us. You, our courts sworn to uphold our Constitution, do not govern us. You, copper kings in your faraway mansions, certainly do not govern us. We govern us. And so they did. They took the initiative power upon themselves, and shortly thereafter, 100 years ago, in 1912, passed the Corrupt Practices Act. And that corrupt practice that they targeted was corporate contributions or payment in support or in opposition of political candidates or nominees. They called it as they saw it, corruption. Nowadays, that law, which some refer to as a ban on corporate speech, I'm not sure anyone in Montana for the past century would say that corporate or any other interests have been silenced. It requires them to fill out a two-page form, file it, and participate in an American tradition of political accountability to real people. You put your name where your money is, you spend your own, not other people's money, on campaigns, and you stand up and be heard. Ironically, a group calling itself American Tradition Partnership from these parts, not from Montana, although we don't know much more about them than a post office box, in the wake of Citizens United, for the first time in this century, a long history, sued to asked courts to throw out our Corrupt Practices Act. Our Montana Supreme Court, to its credit, which like most courts in this country are elected and know something about politics, upheld it and held that Montana has a compelling interest in preserving the integrity of its democracy. Unfortunately, the U.S. Supreme Court, in reviewing American Tradition Partnership's petition, stayed the Montana Supreme Court's decision and left us for the first time in a century without the protection of the Corrupt Practices Act. They conferenced on the petitioner's request for U.S. Supreme Court review of this case in Montana's century-old law on Thursday, and we may hear what happens as soon as Monday. And I guess I'd want to close by suggesting that I hope that the lesson that we're able to take away from this is not the 2012 lesson of abstract legalities or what happens in the halls of the U.S. Supreme Court or any other court, but that the lesson is rather not from 2012, but from 1912, when a group of people, a supermajority across partisan lines, saw corruption, called it as they saw it, and took an important step towards reclaiming their democracy.
Okay, thank you. Great. Next, let's go all the way down to the other end. Larry Gold is a partner with Trista Ross Shadler and Gold here in Washington. He's an associate general counsel for the AFL-CIO. Larry, just tell us a bit about how the unions have responded to Citizens United, what role unions do play and should play in this field.
Well, in the campaign finance realm, unions have really been treated in lockstep with corporations, both profit and nonprofit corporations, for 70 years now, ever since the War Labor Disputes Act in 1943 that extended the corporate contribution ban to unions. The Taft-Hartley Act in 1947 imposed the prohibition on expenditures to both unions and corporations in a bill that was designed, of course, to cripple the labor movement, which was then a much stronger movement than it is today and always has been vital to American democracy. It's under that law, in fact, that the UAW was prosecuted in 1957, and before that, the CIO was prosecuted in 1948, the first case that Brad Smith mentioned. And that's, in fact, the law that Citizens United invalidated. It was carried forward. All the campaign finance laws from 1907 to the 40s were carried forward into the Federal Election Campaign Act, and unions and corporations have been regulated pretty much in tandem ever since. But unlike other institutions, federal labor law imposes all sorts of requirements on unions that are completely alien to businesses and nonprofit corporations, but highly relevant really to campaign finance law. For example, I mean, in all spheres, membership is voluntary. Union membership is voluntary everywhere. Membership in other groups is voluntary. Corporate shareholding is voluntary. But unions are different. They are completely democratic. It's a one-person, one-vote model with respect to election of officers, secret ballot, and in control of their organizations. Unions have a different relationship with those who are affected by them. They have an enforceable duty to fairly represent everybody that they represent, member or not. Non-members have every right to compel the same degree of devotion of resources to their interests as members do, completely like other organizations. And in 22 states, so-called right-to-work states, individuals who are represented by the union and have the rights and qualify for all the benefits of representation don't have to pay a penny towards that representation. This is completely different from how other organizations operate. Unions are also by statute far more transparent than any other organization since the Landrum-Griffin Act in 1959. The threshold now is that, I don't know how many people even know this, every year unions have to file with the Department of Labor and public reports itemizations of their spending and the receipts at the $5,000 threshold. Imagine that kind of an obligation. It doesn't matter what they spend on, and it doesn't matter where the money comes from. Imagine that kind of obligation for business corporations or nonprofit groups that many of us support. You can't have a strong labor. Well, one other point. The Taft-Hartley Act itself also prohibits most corporate payments to unions with very narrow exceptions. Think about that in terms of fundraising for anything, politics or otherwise. You can't have a strong democracy without a strong labor movement and without strong democratic organizations. And whatever one may think about how the law ought to treat other kinds of groups, these are some of the reasons why I don't believe there's a coherent justification to deny First Amendment protection to union political speech that is undertaken without coordination with candidates and political parties. And I think however we approach these things, we really have to be very mindful of these kinds of consequences and the role that particular organizations do play and must play in the United States.
Terrific, terrific. And then there was one. Monica Yoon, a constitutional fellow at the Brennan Center. The Brennan Center we all know and admire very much at New York University. Monica, talk to us a bit about strategies going forward, possible remedies to assuming one thinks remedies are needed.
Yeah, because the title of this panel is Citizens United 2 Years Out, and or something to that effect. And so I kind of didn't want to get drawn back into the debate about whether Citizens United is rightly or wrongly decided. Tons of carbon dioxide and reams of paper have been spent on that question over the last 2 years, and I sort of wanted to focus on what's next. Because this week I got 2 emails from the White House. I got one earlier in the week from David Axelrod saying that President Obama would support a constitutional amendment to overturn Citizens United. And then yesterday I got one in response to a petition that a coalition of advocacy groups had filed saying nominate new commissioners to the FEC. And for those of you who don't have background on this problem, the FEC has been sort of in a state of perpetual deadlock through this and previous cycles. 5 of the 6 current FEC commissioners are serving under expired terms, and the president has, I think, only attempted to nominate 1 commissioner to fill those expired terms. And this week, rather famously, the FEC managed to deadlock over the question of whether or not the White House is a symbol for President Obama when it's used in a campaign ad. It's kind of a stunning air of unreality. So the message I got from the White House's email about the FEC is, oh, we're doing all we can, but really, really, we want to overturn Citizens United. And you know, I found this a little unsatisfying, frankly. There's been a lot of talk, you know, as we know, Citizens United is a progressive bugaboo. It's the shorthand that I think we all use to discuss the current state of our campaign finance system. And I think it's been very useful in that regard. I think it's incredibly useful that people who are not lawyers understand what you're talking about when you're talking about Citizens United, thanks to Stephen Colbert, when you're talking about super PACs, all of this stuff. And there's been a lot of attention lately around the question of a constitutional amendment. Slate has done a recent series on, you know, how would you amend the Constitution if you were given your druthers? And I think that all of that thinking has been very useful at an advocacy, at an engagement, at an awareness level. But, you know, I do think that at some point, one needs to move beyond that. Because to treat money in politics as if it were purely a constitutional question, as if it were purely a question of Citizens United or what constitutional amendment would you like to pass, is in some way to pass the buck. Because money in politics right now is not just a constitutional question, it is also a political question. There are political options that are available to us, even under the existing very constrained parameters that the Supreme Court has put on us. There are options like trying to reinvigorate the public financing system to really break the vicious cycle of candidates and donors. There are options such as strengthening coordination rules, implementing real and rigorous disclosure rules, to overhaul the current regulatory structure so that the FEC, the IRS, the SEC, and the FCC are working together rather than in some incomprehensible mishmash. And you know, all of these things are politically available and politically possible if we are able to muster the political will. But I think it's a little bit too easy just to sit back and say, this is all the Supreme Court's fault, because if Citizens United were overturned tomorrow, we would still all have a lot of work to do.
Great. Marvelous work by everyone. So we have now, let's see, we have about 40 minutes or 45 minutes before we move to audience questions. And so in this next segment, I'd be interested in much more of a back and forth among all of you than everyone returning to me. I have a few questions that I'd like to ask and a few points that I'd like everyone to consider. But let's start now with something that's more like a conversation. And let me just raise a first topic, and then maybe it can roam from there. And let's start again with Fred, whom we now haven't heard from in a little while. But let's talk about the thing that we're all really most interested in at bottom, which is this election. What do you see happening in this election? What is the immediate impact of this going to be in this election, and should we fear that or cheer that?
Well, I don't know about fear or cheer. The immediate impact in this election is going to be felt in a couple of ways. Most of the money in this election will be spent by candidates and parties subject to contribution limits and disclosure. The large, focused, targeted money will be spent by groups using unlimited contributions and or secret money. And this provides an enormous advantage in selected races for very wealthy people who can give large amounts of money to super PACs, and for those super PACs, for organizations that are really, in my view, laundering secret contributions into the federal elections. And you're going to see a lot of money focused on a relatively few races. You're going to see money focused on the presidential target states. You're going to see it focused on 6, 8, 10 Senate races, 20, 30 House races, and that's laser beam focused because these groups have, relatively speaking, enormous amounts of money. Right now, the Republicans have the bulk of this money, but that's not the issue. It never is. I mean, because this isn't a question of Republicans or Democrats. It's a question of what's the impact of this money on our electoral process and on our decision making. And if anyone thinks this money is not going to impact on decisions in terms of the people who support the winners, I think you better think again. So I would be surprised if almost all of the TV time in the fall is not bought up already in these targeted states. To me, in a very dangerous system, the single most dangerous entities are the candidate-specific super PACs, because they're not independent from the campaigns. They're arms of the campaigns. They're run by close associates of the candidates. The candidates are raising money for them. They spend money only on the candidates. You can define coordination properly that will prevent that. And we've drafted legislation to do that. You can do it within the Citizens United decision, which says the activities have to be independent. You know, when the Supreme Court has talked about independence, totally independent, fully independent. You think that's going on now? I don't think so. So if those kinds of super PACs continue, in the next election and the following election, any incumbent member who has a targeted race is going to have a companion super PAC raising unlimited money, and you are in the process of eviscerating contribution limits. Now, the opponents of these laws are going to use this as an argument for saying, well, great, let's just repeal the laws, let the candidates and parties get the money, and we'll have full disclosure. Except, as you've seen from Senator McConnell's speech yesterday, if anyone read about it, the opponents to these laws are now after disclosure. They want to get rid of disclosure as well, despite the fact the Supreme Court by 8-1 has upheld disclosure. So I think we're going to see real impact in this election by the nonprofits and the super PACs. It's going to be interesting to see whether they really can decide a presidential election. They certainly have the ability to decide Senate races and House races.
There's an article in the New York Times this morning, I assume in the Post, I didn't get the Post, I didn't look at the Post yet, but about McConnell's speech, which was on exactly this point, which I want to return to. But who wants to follow up now here, rebut or expand on the question of influence in this election?
I hesitate to use my time not aggressively advocating one position because I'm not sure anybody else here is going to do it, but I'll do that anyway and say we need to talk actually frankly about what the disclosure debate is about. For example, if you listen to Senator McConnell's speech yesterday, he did not call for repealing any of the current disclosure on the books. There's a lot of disclosure that is currently on the books. For example, every advertisement, we know who paid for it. We often don't know as much as we would like about who paid for it, because it might be a group, it might say the U.S. Chamber of Commerce, and it might say something much more obscure, like Republicans for Clean Air or something like that. But we do know in the first instance who paid for it. So the question becomes, how much disclosure do we want? Should we have? How far should we go? Nobody's talking about rolling back disclosure. In fact, what's going on actually is that people have been talking about extending disclosures in ways that it has never been extended. We have never required membership groups, 501c4 organizations, to disclose their donations. And this goes back to cases, Bates versus Little Rock, NAACP versus Alabama, that had to do with efforts to silence civil rights activists back in the 1950s and the 1960s by opening up their membership rolls and their donations so that those people could be harassed, bullied, intimidated, and so on. Now, you might say, well, that's not relevant to the Kochs and stuff. That's fine. I don't want to debate that right this instance. I'm just pointing out that That's the background against which we operate. That is still the disclosure laws that are in place. So if a 501c4 runs an ad, we know that the 501c4 paid for that ad. And most of the time we know something about it or can fairly readily find out something about it. So I think it'd be fair to have a good debate about disclosure and how much disclosure we should have. And I think it is true that sometimes we don't know exactly who contributed the dollars that were spent by some group. But I think that we need to be honest here that there's not a talk about rolling back disclosure. What we are talking about here is whether we should have new disclosure that has never before been adopted, and doing that would be disclosure that is not anything the Supreme Court has ever sanctioned. The Supreme Court says, yes, disclosure is an acceptable remedy, but it has never sanctioned some of the specific proposals that are out there.
I have something I'd like to say, but I have a feeling one of you is going to say it. Go ahead, Fred, then Zephyr, then Anthony, then Mark.
You know, the Supreme Court in Citizens United upholds the disclosure regime for electioneering communications. That regime, existing law, requires groups to disclose their campaign-related expenditures and the donors funding them. Now, we would be getting this information if the FEC, in its wisdom, had not gutted the contribution disclosure limits. We're representing Representative Van Hollen in a lawsuit that we recently won that would put back into place that disclosure. So the idea that we've never required contribution disclosure for these groups is just not correct. Secondly, Citizens United has changed the world. Prior to Citizens United, C4s could not make direct campaign expenditures because they're corporations. Post Citizens United, we have groups like Crossroads GPS who claim to be social welfare organizations. I'm not familiar with the social welfare work that Karl Rove does. And therefore, their overriding purpose is elections. And they and their associated PAC are going to spend up to $300 million in this election. Now, we happen to know that there are 23 contributors of $1 million or more to Crossroads GPS. We do not know who they are because the tax returns for C4 organizations or people who claim to be C4s require you to disclose the amount of the contribution, but not the name. We have the Chamber of Commerce who says they're going to spend $100 million in this election, and they're going to spend it in direct campaign expenditures. Not one of the corporations whose funds are going to be used for those campaign finance activities are going to be disclosed. And one last point. The McConnell decision distinguished NAACP from campaign finance laws. And it said campaign finance laws are different from the kind of work that real advocacy groups do. If people are spending money to influence elections, citizens are entitled to know who is putting up the money. It's a protection against corruption and the appearance of corruption. The court has been clear on this for 40 years.
Zephyr, Anthony, Monica, and then I saw Larry also raise his hand. So.
Well, I just wanted to make a quick comment, I think picking up on Fred's response, that the game has changed a little bit with 501c4s. The challenger to the Montana law, American Tradition Partnership, it was Western Tradition Partnership. That's all part of the shell game of morphing and changing to make accountability more difficult. Is a 501c4, and this is the pitch it made to corporate donors. There's no limit to how much you can give. As you know, Montana has very strict limits on contributions to candidates, but there's no limit to how much you can give to this program. Basically a substitute for contributions. You can give whatever you're comfortable with and make as big as an impact as you wish. Finally, we're not required to report the name or the amount of any contribution we receive. So if you decide this program, no politician, well, except for the politicians you're supporting, right, because you can tell them there's one-way disclosure, but no politician, no bureaucrat, no radical environmentalist, I might add, no actual voter, will ever know you helped to make this program possible. The only thing we plan on reporting is our success to contributors like you who can see the benefits of a program like this. you can just sit back on election night and see what a difference you've made. This is the pitch that is now being made.
Wow.
It is expressly to get around contribution limits, to get around these issues. Now, is that coordination? Is that corrupting? I think that's an important question to ask, and it's not one that Citizens United or any of the prior laws have answered. And American Tradition Partnership is a poster child for these problems of accountability.
Really interesting. Zephyr?
I just wanted to return to something Anthony said earlier, which is that, you know, what I see is an effort to shift the debate to what I guess what I see Brad doing and other people doing is try to shift the debate to sort of some ancillary concerns about some individual things that are happening on the margins, when what we're talking about is money and power and responsiveness and allowing states to see corruption, call it when they see it. And one of the key things to be able to see corruption is to know actually what's happening, and to be able to follow power when people are investing $100 million to make back $100 billion. And I mean, in some ways, it's sort of a question for all of us, is how to respond to this effort to sort of shift the debate to anti. I do see that there's a really aggressive move to move against disclosure, against necessary disclosure. And I want to return to something Fred was talking about. This election, we're going to see a lot of super PAC activity, but it's going to be a lot worse in 4, 6, 8 years. And so this time is incredibly important to be able to know as much as possible about what's happening so the people can then respond in their local democratic way with the kind of activity that Monica's talking about, with like getting the SEC engaged, more serious knowledge about what's going on, and really importantly to get public financing, because right now that's one of the few areas where we see the possibility of the public still having some responsiveness in election.
Monica.
Just 2 points. The first, I was very surprised to hear Brad say that no one is talking about rolling back disclosure, and I think another person who would have been surprised would have been James Bopp, who, since Citizens United, had filed at least 15, 20 lawsuits challenging existing campaign finance disclosure regulations, and who told, I think, the New York Times in the week after Citizens United was decided that disclosure was the next target in the sort of conservative juggernaut of lawsuits seeking to deregulate the campaign finance system. But the second point kind of goes to Fred's point and to Zephyr's, which is, you know, Sheldon Adelson, for better or for worse, has become the poster child of what's wrong with this cycle of campaign finance. And I think that in some way that is misplaced, because we know that Sheldon Adelson wrote a $10 million check and has written several $10 million checks. Well, American Crossroads has received 2 single $10 million checks. We don't know who those are from. There was no disclosure because they were funneled through the Crossroads nonprofit. So we know there are these 2 $10 million checks floating out there. We don't know whose line is on the signature line. Now, I can tell you that Karl Rove knows whose name is on the signature line. I can tell you that other people are going to know whose name is on the signature line, but the voters, the reporters, the press are never going to know who wrote those 2 $10 million checks. So if you want to put somebody on a poster, you can put a big black box on the poster and say, this is who is responsible for this system. And now Karl Rove is explicitly claiming that they should be exempt from disclosure because American Crossroads is like the NAACP in Alabama in the early 1950s. And I think that anyone who hears that should be outraged. The idea that robust discussion and criticism is somehow equated to lynching should be something that people should just stand up and walk out of the room when they hear.
After Larry,
I kind of need to cut in at this point.
Larry,
I know Larry, but
Go ahead.
Karl Rove hasn't said that they're like.
He said it.
No, he did. He said NAACP protects our rights to keep our members secret. That's very different from saying we're like the NAACP. And that's what I mean when I say that this debate is not one that we're having in a real tone in which we can honestly kind of debate these things. And like with the C4s, Fred mentioned C4s, you know, used to not be able to contribute. See, I agree with that. The game has changed. And if you want to argue that because the game has changed, we should have new disclosure, that's okay. And that's what the discussion's about. But let's have that as an honest discussion, not at this, well, we don't, they're changing things, they're trying to fight off things. C4s, prior to Citizens United, could run ads that would say, you know, Barack Obama is destroying the United States of America. He's in bed with terrorists and was born in Kenya, and, you know, call the White House and call Barack Obama and tell him to stop his agenda to destroy America. And that was perfectly legal, and they didn't have to disclose their donors. So the shift is not so radical as it appears. Now, again, there might be a reason to want more disclosure, there might be a reason to want more disclosure, but let's have that debate in an honest way, and we don't need we can look at what the precedents of NAACP mean, why they're important. How are you going to distinguish between Crossroads GPS and the NAACP when you start setting up a legal regime and other groups that will fall somewhere in between? But let's have that debate in a fashion where we can come to some reasonable suggestion rather than kind of suggesting that the law is somehow being rolled back in ways that are simply not true, or that people are saying things they haven't said.
Larry?
Yeah, I do think that, you know, in approaching this, approaching disclosure, any of this, we really have to, you know, focus very specifically on what it is we would want to change and look at who it would affect and how. You take 501c4s, that's a non-ideological category. That's a category for all social welfare organizations, a broad IRS standard established many years ago. It includes NACP, it includes American Crossroads, the Sierra Club, the National Right to Life Committee. And, you know, some of the disclosure rules that are being suggested, the one Fred mentioned, you know, I think progressive groups have to think, is that really, how is that going to affect us, and is that really just? The electioneering communication litigation that is being waged right now, you know, one view, which the court has upheld, is that if an organization does an ad within 30 days of a primary, 6 days of an election, a broadcast ad, and spends $10,000, even if it is an ad saying, call Congressman X and tell him to vote against the right to work law that is up in the House tomorrow, that organization is required then to disclose every donor to the organization of $1,000 or more since the previous year. $10,000 survival ad could trigger millions of dollars of disclosures of donors by an organization that, for many good reasons, I'm talking about progressive C4 organizations, might have a reason and a history and a pact really with their donors for all sorts of reasons not to make those kinds of disclosures. If that's the kind of regime we want, then, you know, we really need to consider that carefully, and it needs to be prospective. I mean, one problem with the current litigation is you're dealing with an FEC regulation that was, and a statute that was enacted under one set of assumptions and didn't apply to C4s and didn't apply to unions or business corporations, and by virtue of judicial law, including Wisconsin Right to Life and Citizens United, you know, change the impact of the statute. It really isn't sufficient for us and our concern about the impact, I think, of the wealthy and of right-wing organizations to just say, well, you know, then, you know, everything should change because the consequences are going to affect everybody. And are we willing to live under those rules, and how is that going to affect the way we operate politically?
Mm-hmm.
I guess, I mean, I think for me, I don't start with being concerned about conservative or democratic, or I'm largely democratic. I start about being concerned with non-representative, non-self-government. I think in human history, oligarchy is the default. Oligarchy or monarchy or some kind of tyranny is the default. It's extremely rare to have a self-governing society where representatives, those who govern, are actually truly responsive. And so the citizens, we have an extraordinary country in this way. We have an extraordinary country that has developed a really unusual civic culture where people really actually do feel responsible for government and come together and ask, what should we do? What is in the public interest? And in this sort of global sense, the fight against the oligarchic tendency is hard and it's dynamic. It means that in the 18th century, perhaps the response is to focus on limiting terms of representatives, which is something that the length of the term of representatives was sort of an anti-corruption provision within the US Constitution. In the 19th century, you see courts refusing to enforce corrupt contracts. You see Georgia enacting criminal laws against lobbying In the late 19th, early 20th century, you see antitrust laws as anti-corruption measures, and you see the beginning of limits on corporate spending. In the post-Watergate era, you see what we call campaign finance reform. I think of it as sort of an extension of this suite of anti-corruption measures. But this is an ongoing, difficult, dynamic debate that requires taking on new forms of power and entrenched power in new ways, requires disclosing power, I think, wherever we see it. And I do worry about a short-term vision that's protecting certain forms of liberal power at the cost of not taking on all kinds of entrenched power.
I think Monica, then Fred. Okay. Wanted to speak.
Sure. I just wanted to respond a little bit to Brad's point, because I agree with Brad. It is a very complicated question, the question of disclosure. And it's one that, when the Supreme Court considered it in Doe versus Reed in 2010, they were pretty much unanimous on the facial challenge. To disclosure laws 8-1, but they split very widely and very seriously about the question of what level of harassment should be required to justify one for the harassment exemption that was at issue in NAACP versus Alabama and a couple of other questions. And a couple of other cases. And I do think that there are real policy questions as to what level of disclosure is appropriate. We do want to combat corruption. We want to be able to know who is buying influence, but we don't necessarily want to deter small donors who are interested just in making their voices heard. And I think that's an important and a very substantive debate to have. What I'm responding to, I think, in my comments was this kind of pervasive elision of that distinction, that anytime the press looks into what Sheldon Adelson is trying to buy with his money, that is somehow unconstitutional harassment that's violating his First Amendment rights, when in fact what the First Amendment is supposed to be about is about vigorous and robust debate and criticism coming from both sides.
Fred.
First of all, in terms of the 2002 law that Larry mentioned, and more importantly, the pending Disclose Act in Congress, there are alternative options in there that provide the opportunity for only those people whose money is actually being put up and used for campaign expenditures to be disclosed. And that kind of option exists in the 2002 law as well. They also provide options to ensure that no one who does not want their money used for campaign activity would be disclosed. So it ends up that if an organization is using someone's money for campaign activities, it's going to be disclosed. And I think that's pretty focused. And on the threshold question that Monica talked about, the thresholds are high for when you start disclosure because you're trying to get significant contributions. Mm-hmm. But let me make one comment. Monica mentioned Doe v. Reed. One of our traditional allies on the Supreme Court, Justice Scalia, had this to say about the disclosure requirements for ballot measures in Doe v. Reed. Requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed. I mean, the court is 8-1 on this disclosure question, and we can fight over some of the details. But the idea, as Senator McConnell said yesterday, that the efforts to obtain disclosure come from the political left in the Obama administration and are an effort to stifle speech. His speech conveniently left out that the Supreme Court, by 8-1, has supported disclosure for the very kind of outside groups that are making the undisclosed contributions now.
Brad Smith, isn't it the case that, as I understand it, the conservative alternative to McCain-Feingold, the beautifully named delay Doolittle bill, that was its name. Let that sink in. Said, no limits on spending, no limits on donations, but immediate disclosure. And that was the conservative position, but now that's kind of not the conservative position, right? Now McConnell is backing off immediate disclosure.
Well, I think there are a couple of things here. Again, we've been talking about a lot of new disclosure, but I think that there are some things that are, as has been suggested, changed, and we should think about. For example, it used to be when you had political disclosure, that meant somebody had to go down to the FEC offices and essentially look at paper reports or scroll through microfilm later on. Nowadays, this kind of thing can be put immediately on the web, and in fact, there are sites such as the Huffington Post and 8 Maps where you can call up. You could probably do it with us sitting here, and if you've got your laptop with you and you're hooked up to the internet, you could do it now, and find not only what we gave, but street maps to our homes. And so there's a different dimension to disclosure and its invasion of privacy of small individuals. Another thing that I noticed during my time at the FEC, this is when it really came home to me, was the way in which disclosure laws really burden small grassroots politics. It's fairly easy for a small grassroots group to understand, okay, I can't take corporate money, can't take a contribution over $5,000 or whatever, nobody's going to give me that much anyway. But it's very hard for them to fill out all the forms. That's complex, they run afoul of the law, the next thing they know they're getting sued, and they're usually getting sued by some bigger, more established player who goes after them. So I do think that, and I guess the one other thing I'll say is that there is a difference that is historically the Supreme Court has supported disclosure for 3 reasons: to assist in enforcement, although that doesn't necessarily require public disclosure. I mean, we could assist in tax enforcement by making everybody's tax returns public and online, and we don't do that. Second was to help voters spot patterns of corruption, and this is why I and our organization, the Center for Competitive Politics, we continue to support disclosure when we relate to truly large donors, when we're talking about people like Sheldon Adelson. And then the third issue was to help voters judge the content of a message and the value of a message. Where's it coming from? But what we see now is people who are not using it to determine can they trust this message or not. Rather, they're beginning from the position, I hate this speech. How do I find out who's responsible for it and take action that will harm them in some way so that they will stop speaking? And I think when we see these different dynamics come into play, I think it's natural that people begin to rethink a little bit what was earlier sort of idea, well, of course we'll just disclose, that you begin to see the problems with it and recognize again what a complex issue it is. So I think that there are some things that can be done, but I think that again that debate has to be held in an atmosphere in which we talk rationally and reasonably about what people are actually disclosing now. We found when the Disclose Act was up before Congress, we'd go around to senators and show them, hey, here's what's actually disclosed at this point. Here are the forms, here's what they look like. And the senators were like, Shazam, holy, we never knew that. Nobody's told us that. We thought none of this was disclosed. So I think there's some change there.
I have a feeling someone would like to rebut that.
Let me just read from Citizens United what 8 justices signed on to on the issue of internet disclosure. With the advent of the internet, prompt disclosure of expenditures can provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. Shareholders can determine whether corporations' political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are in the pockets of so-called moneyed interests. The Supreme Court saw internet disclosure as a value, not a danger at this stage in our society.
We have about 15 minutes before we go to audience questions. I want to return to the question of solutions and remedies before we turn it over. But I'm very curious at people's thoughts about this one matter, which I wanted to ask you about, which is the Jeff Toobin piece in the New Yorker just recently. Everyone read it, I take it? For those who might not have read it, he describes some behind the curtain, very rare behind the curtain, machinations that happened at the Supreme Court that led to the Citizens United decision. Just starting anywhere, Zephyr, just your reactions to that piece and what it means about the court and what it means about can this head even further in this direction?
I guess I keep wanting to switch the conversation. So,
yeah. Switch away.
Okay. No, I mean, I guess one of the, and I'm not saying it right, but one of the things I think is so important with what Anthony's talking about is for those of us, whether you say as progressives or as small d Democrats, to really focus on the importance of democratic dominance in this area, that I want state legislators and Congress to be able to respond to real concerns about corruption, as opposed to having this happen within the court, which is completely out of touch. The least politically experienced court we've ever had. Really doesn't understand the nature of power, the nature of money, because this is really about power and money. This isn't about speech. And then, given that, return to questions about what we can do, because I guess I do worry a little bit that we're confusing questions of what we want, what the court thinks is constitutional, and then where's the right place to have this discussion. I don't think the right place to have this discussion is necessarily here, although we have lots of solutions. I think the right place to have it is in state legislatures and in Congress. And even having it in the court seems to be the wrong place. And as constitutional scholars, we tend to move to the court as opposed to the state and congressional forum.
Mm-hmm. Anthony?
No, I'd agree with Zephyr's agreement with me. This is too court-focused, and I think it's something about reviving an American tradition about accountability and anti-corruption. And I think, as Brad said, I think there's actually some overlap. There are things that Fred and Brad agree with. Right? They agree with each other on some basic things. The reason we're not going to see that put into play is because of dysfunction in this town that is bleeding out. Our governor had a unique way of putting it on the New York Times op-ed page. He asked whether the Supreme Court would blow the stench of Washington out to the clean mountain air of Montana in this case. But I think there's something to it. When reform groups are looking to the IRS as the new vanguard of transparency in 501c4s, there's something deeply broken about Washington's solutions to this problem. So I'd suggest, I think there are opportunities. Fred and Brad agree on some basic things about disclosure, fixing some things. Why aren't those things getting done? And if they're not getting done here, might they get done in other places?
I think you're underestimating the basic disagreements about this issue that involve strongly held views by opposing sides. And at least at the national level, those occur at a time when it's almost impossible to get anything done in this city. This city is gridlocked in a way, and the Congress is gridlocked, and the government is gridlocked in a way that I haven't seen in 40 years of working on this. So there are very fundamental differences. I mean, for example, we, like many others on the campaign finance reform side, strongly support public financing. The opponents of this strongly opposed public financing. In this setting, with the framework we have to operate from the Supreme Court, our only response to all of this money is citizen contributions, and they have to be made more important, and that involves matching funds. I haven't found it yet. I mean, we've had it before on bills. It's not there right now. In 2000, we passed a disclosure law for 527 groups when a loophole occurred there. The vote in the Senate for disclosure was 92-6. The vote among Republicans for disclosure for 527 groups in the Senate was 48-6 in favor. Mm-hmm. McConnell was one of the 6, so he has been consistent here. He's not inconsistent on disclosure. 10 years later, when the Disclose Act came up in the Senate, not a single Republican voted for it, and not a single Republican would discuss changes in the bill that would get their vote. And that is a product of changed times, the deep partisan divisions, the complete focus on we're in control, we want control, we lost control, we want control. It makes very, very hard to get policy solutions, particularly in this area, because we're talking about how people win and lose elections.
Brad, what would be the principled libertarian objection to public financing, a New York City style program? I understand there'd be other conservative objections about the role of government, but what would be the libertarian legal?
Well, I mean, there's practical issues, and then there are, I think, what are kind of theoretical, ideological, constitutional issues, whatever you want to call it. At the most practical basis, you have to recognize this. If you have public financing, you haven't done away with the question of super PACs at all, and independent expenditures and large amounts of money going through there. And that's the question, is how do you get a handle on that? How can you stop citizens from speaking? That's been the big issue. And that's why the court, including many of its most iconic liberals, such as Douglas, whom I quoted at length earlier, have said you cannot regulate this kind of activity. Now, I think from an ideological perspective, there is a belief that simply the government should not be involved in elections. That is, it should not be involved in perpetuating itself, and that inevitably, over time at least, it will develop systems that tend to favor incumbents, if for no other reason than the incumbents will not change it if it benefits them, and they will change it if it does not. And that is a problem that we deal with. So I think there's both a kind of a long-term public choice constitutional rationale that fits in, and then the practical problems that I just don't think it solves anything. I mean, we've had public financing in various forms in various states at the national level in presidential races, and all of the same complaints are made at the end about power and corruption and those concerns, and those are real concerns. Public financing doesn't make them go away.
Monica?
Yeah, I think that there was I've litigated a number of these public financing cases before and after Citizens United came down. And I think that especially when the Arizona Free Enterprise Freedom PAC, or whatever they're calling McComish now, case was decided, there was a real worry among progressives that was, oh, this is the end, this is the death knell to public financing. And the fact is that just doesn't seem to be true. Public financing seems to be weathering the storms of both Citizens United and the McComish case. And this is even in instances in states where there have been massive influxes of independent spending. For example, in Maine, the National Organization of Marriage has decided that's one of their target states. They've brought a lot of outside super PAC and independent spending into the state. But I think that, or in Connecticut, which I litigated both before and after the particular triggered matching funds of their public financing system were struck down. But what you found was that as long as there was enough money to ensure a robust debate, then money did not become destiny. And that, the candidates in places like Connecticut, Maine, Arizona were able to get their message out and were able to say, look, I'm doing this with your money, not with money from secret sources, and that message really resonated. Similarly, in New York City, in response to Brad's point about political culture, I mean, having spoken to people who have been office holders both under the New York state system, which does not have public financing, which has extremely high contribution limits, and under the New York City system, which is a comparably expensive media market, but which does have public financing, they say the difference is like night and day. The difference is spending all of one's time in ballrooms, glad-handing major donors and special interest groups versus going to backyard barbecues and meeting the people who one actually represents.
May I, here, now is where I moderate. It's 10:20. We're going to start audience questions in 5 minutes. I hold here in my hand, like Johnny Carson in the Karnak days, the audience questions. But I want to ask a final question, and we'll start with Larry and run down toward me. Just a question about remedies, an open-ended question about remedies. You're the emperor. I've made you emperor of the United States and the campaign finance realm. In a minute or so, what would you do?
I guess I would start from the point of view of doing everything to encourage and engage civic participation, protect the right to vote, maximize the ability of individuals to speak, and for organizations to collectively participate in the political process. And that's why I come back in part to the point I raised earlier about contrasting unions, not just to favor unions or to single them out, but it raises a fundamental question about how is it that we regulate and to what degree do we evaluate truly democratic institutions? And the fact is that criminal prohibitions against unions or other groups for speaking, groups like that, raise really serious questions. I don't have a grand solution. I think public financing can play a very constructive role, in part because it does relieve candidates of the burden of fundraising. And I think that's principally why they like it. And I think that it's certainly healthier if they spend more time doing their jobs than raising money. But I don't have a grand solution, but I think your question is the right question, because there's a lot of complaining about the way things are, and I think there's a paucity of clear and simple solutions that actually honor our traditions.
Monica, grand solution.
Sure. I don't know that I can identify a silver bullet. I think a lot of people have been trying to over the last couple of years, and it's a pretty hard thing to do. But I would say that the emphasis needs to be on participation. And I think that the failure to recognize participation is exactly the problem that led the Supreme Court down the path that we currently find ourselves on. That it needs to be about small donors, it needs to be about engagement. And I would say focusing on solutions that have that commonality is the way that we're eventually, hopefully, going to get out of this mess.
Brett?
I'll echo, there's not a clear answer. On a personal level, I'm largely deregulatory, but in the context of living in a real world where these are real issues and people have different views, I would suggest that at a minimum we need to raise substantially contribution thresholds, which are nowhere near what they would be had they been adjusted for inflation as to what they were when they were passed in the 1974 Act. Similarly, we need to dramatically raise individual disclosure threshold. We don't need to know the identity of every person who gives $200 to a campaign, or at the state level in some states $10 or $1. We just don't need to know that. That's a violation of privacy, of norms. The idea that you have to report your activity to the government, your political activity, should be foreign to us unless we have a really justifiable reason, and we don't have that with those small donors. And I would suggest that we need to think then about a disclosure regime which balances off the very important issues that I've sort of just highlighted there between privacy, between fear, whether it's real or not, of retaliation, between the idea that people just, maybe they shouldn't have to have a great deal of courage. Maybe you shouldn't have to support a candidate and have to put up with getting foul emails in your box and people popping you the bird and stuff like that. And thinking more seriously about it. If I can elaborate just one quick second, like you take Citizens United. The law on Citizens United prohibited $1 in corporate expenditure. If an executive is sitting there at his desk and he writes a letter to a friend saying, I think you should give some money to Romney, and he pulls a stamp out of his petty cash and puts it on the envelope, he had violated the law. Now, if you just read the court's opinion, it wouldn't have changed no matter what. But opinions are written differently depending on the facts. Suppose there had been a law that said a corporation can't contribute more than $100,000 or can't spend more than $100,000 or something like that. I think you might have had a very different decision. I think this all or nothing approach sometimes has led to results that then people like even less. So I'm open to compromise.
Fred and Zephyr and Anthony, if you could be fairly quick.
But first of all, we have to know what's going on. And we're not going to know what's going on in our elections at the national level. There are going to be hundreds and hundreds of millions of dollars spent to influence voters without voters having an idea or a clue about who is putting up this money. So we need to solve a very serious disclosure problem. Secondly, Brad's right in saying we're not going to get rid of super PACs per se, although I truly believe we can get rid of the kind of candidate-specific super PACs that are arms of the campaigns this year. The only way we're going to compete with the flood of influence money that is going to keep coming and growing is by engaging citizens. It's the citizens' participation that people are talking about, and the key to doing it is both the matching funds approach, which empowers citizens and it gives them an incentive. It makes their money more important. That has to be married with fundamental breakthroughs on the internet so that the internet and internet giving can serve as the vehicle for millions and millions of citizens to participate directly in the elections, support the candidates they want, Candidates today do not have an option in the way they raise their money, particularly if they're challengers. They have to go, by and large, they're either very wealthy or they have to go to very interested groups to get money. There has to be an option for a candidate who wants to raise money without becoming obligated in the way people are today.
So matching fund programs that allow people to raise money then gets matched are, I think, the most important short-term solution right now. There's a big fight in New York State. Progressive should not support Cuomo unless he comes around and makes this a leadership issue for him. New York can be a model for other states. Unlike what Brad said, it actually makes an enormous difference. It changes who runs. It changes how they think about their job. They are responsive to those who donate to them in either scenario. So it has a real change in the job of being representative. I think it's incredibly important to focus on those states that are doing matching fund work. And the second thing is I think it's really time for new antitrust laws that break up the big corporations and don't allow them to amass the kind of economic power that they have. It's the oldest form of campaign finance in this country, and I think it's another angle we should be looking at.
All of the above. There are some great ideas. I don't think that there's a grand solution. This 40-year dance between Congress, the courts, and the Federal Election Commission has left us worse off than we've ever been. And so my suggestion is there are some great ideas. Let's ensure some basic political equality. Congress once did great things for voting rights. The courts have been very good at vanguard of protecting basic political equality. Beyond that, let's try getting Washington out of politics and go back to the states where the ideas are and leave them alone for a while. Stop helping.
I note with interest that no one mentioned Buckley v. Vallejo. Maybe that's just a lost cause at this point.
That was the beginning of the dance. That was the first step of the courts.
You implicitly mentioned it, but I was waiting for the... Anyway, audience questions. The first is one that can be answered by one person and can be answered quickly, and it relates to something that the esteemed Linda Greenhouse, sitting here, asked me to get clarification on before this panel started. Please give a legal definition of super PAC versus regular PAC and tell us where super PACs suddenly came from. Technically, they came from the Speech Now decision, didn't they? Is this primarily a regulatory issue or a constitutional one? If just one of you will do this clinically, quickly.
Fred, do you want to volunteer?
Well, I mean, super PACs are registered federal PACs that make unlimited expenditures from unlimited contributions that come from individuals, corporations, and labor unions. The Speech Now decision is part of it, but if you read the Speech Now decision, it is explicitly based on the Citizens United decision. It says, based on the Citizens United decision, we rule that it's unconstitutional to limit individual contributions to groups making independent expenditures. Citizens United freed up corporations to make those contributions. Speech Now, citing Citizens United, freed up individuals to make unlimited contributions.
Real quick,
Larry wants to add something quickly.
Oh, okay.
Yeah, you know, you mentioned Buckley, which is really important, and I'm a little surprised that people are not, when you ask about solutions, whether people think Buckley should be overruled.
I do. Someone out there asked, is the original sin Citizens United or Buckley?
Right, and expenditure limits and the like, but you know, without Citizens United, you already had a federal court of appeals case. The Fourth Circuit in 2008 had ruled that independent expenditure committees, so-called super PACs, were constitutional. You could not preclude unlimited contributions to a vehicle that only did uncoordinated, political speech. So even without that decision, there might be those. But I think that's the real, the real question. A real question is, how do people feel about expenditure limits on what individuals, groups can spend on political speech, and how do you define the speech that can be prohibited, and what sanctions are you going to support? These are really serious questions, and that probably we should be delving into a little bit more.
Brad
Michael,
Smith,
if I
you wanted
can,
to
two
say
real
something
quick
quickly?
things on what Fred said. To be specific, Fred said super PACs do expenditures, and what's important is they do not contribute directly to candidates or parties, and they're subject to all the same disclosure as a traditional PAC. The C4s are the ones that aren't disclosing their donors.
Okay, now,
And we would have won speech now anyway.
let's ask this interesting,
Reality is reality.
let's ask this interesting question. As a practical matter, isn't the best campaign finance reform, with no First Amendment problems raised, changing TV licensing or providing free or very low-cost campaign commercials in the 3 months before the presidential election? Most of the unlimited money now goes to such commercials, and I know as a journalist that 70-something% of money raised goes to ads, at least in presidential campaigns, television ads. So what about this as a solution? It just removes the need to raise the vast majority of the money.
Well, free TV, low-cost TV arguments have been around for some time. It's part of a solution that would help. TV advertising is the cash cow of local television stations. They make a fortune off it, and they're not very interested in changing the rules that apply there. But I believe there's an argument for at least having reduced cost television. It would take the pressure off raising money, but it wouldn't deal with the fact that there's a lot of incentive in giving contributions wherever you can to gain access and influence.
The rates they pay, or the rates campaigns pay, are already lower, correct, than the rates commercial
yes and no.
advertisers pay.
And that's not really in the end.
I mean, so just to distinguish between different kinds of questions, I think this goes to Buckley Vallejo. One question is, what kind of Supreme Court decisions should we have? I think we should overturn Buckley versus Vallejo. I think the court's elite interference in popular response to corruption has been a disaster. The second question is, what can we do given the current scenario? And I just want to separate those out.
Sure.
I
Monica.
think that this does go back to Buckley and Vallejo, because what Buckley and Vallejo did, I mean, put aside the constitutional issue with Buckley versus Vallejo, but what it did from a regulatory perspective is it created a massive and unresolved supply and demand problem that continues to haunt us. It said that basically we're going to allow for unrestricted demand expenditures. You know, you can spend as much as you want, but you can only take in certain increments. And this, of course, led to all kinds of, basically black market or gray market solutions springing up in which people tried to, funnel funds into that supply vacuum. And I think what's being discussed here with respect to the broadcasting rates is a sort of demand side solution, but only a partial one. It's saying, well, you're not going to have demand for money anymore if we give you these rates. And the problem with that is people always come up with different kinds of demands. It's like telling a child, like, I'm going to give you all the candy you want, and therefore you're not going to want anything else from me. I just, I don't think it's going to happen.
Okay, here's a good question that I have to ask in a room full of lawyers. What can litigators do to help roll back the increasing influence of money in politics? Are the courts the right venue to be waging this fight?
Well, I think goes to the last question. No, courts don't know this stuff. Yeah, they know the First Amendment. I think they've championed it, but we're getting into very abstract libertarian debates that just don't reflect reality. I think what litigators can do is to get out of the litigator, take off your litigator hat and put on your general counsel hat and start thinking about institutions and rules and the things that you learned in law school and how to solve problems by designing effective rules in response to a changing environment. Just be lawyers about this stuff. Not litigators. We need more general counseling about problem solving and clear rules that political actors can follow with accountability, and less litigation.
No one else?
Although having, with Fred and a couple of other groups, been trying, I think, to stem there is a tide of deregulatory litigation being advanced that I think that some of us have been trying to represent the other side on, and we are kind of drastically outmanned.
And I would be ungrateful not to thank Monica's group and Zephyr and Fred and many others who have been helping not just us, but the states in general fight these court battles, so we can leave space to have the discussion that we need to have.
You can't pass laws in litigation.
Yeah.
You can defend existing laws, and there's huge battles still going on, as Monica said, and we and the Brennan Senate or others are involved in a whole lot of defensive battles, and depending on what the Supreme Court does with our friends from Montana, we all may be very active next year, although I think people are somewhat skeptical about that's going to happen.
And now I got to get it first. You can also attack laws. For example, my group, the Center for Competitive Politics, was representing a little pro-choice group in Colorado that's being harassed and silenced by the state's ridiculously low thresholds for having to register and report with the government about their political activity. It's a pro-choice group. There are things on both sides. And the other thing I'll say for this audience, Rick Hasen, who I think all of us know and would be more with my colleagues here today than with me, says the other thing you can do as liberals, lawyers, is stay out of the Roberts Court.
Yeah. That's been a strategy from day one of the appointment.
Although I should say, in response to Rick's suggestion that we're not trying to get in the Roberts Court. We won. We won in Montana. Yes. It's the other guys who are trying to drag us, kicking and screaming, into the Roberts Court, and we'll see what they do with us.
Maybe Mr. Verrilli should have taken that advice. Sorry. Okay. Here's an interesting question of sort of political philosophy that sort of gets right to the heart of things. This might have to be the last question. We might have time for one more. Is political equality a constitutional value of sufficient weight to balance against First Amendment liberties? If not, what is the real world purchase of the one person, one vote principle? I like that question.
So, I mean, first of all, the question assumes that we start with a strong First Amendment, which I think is sort of totally out of whack, as some of my friends have heard. An old colleague of mine said the Supreme Court went and got drunk on the First Amendment, didn't it? And in this area, this is about power and money. This isn't about speech. So I reject the premise. That said, there are two real deep values in American constitutional history. Three: liberty, political equality, and a fight against political corruption. And I just would say that those are slightly different things. And political equality is a separate and really important value. You're not allowed to mention it to this court, but it is a real deep constitutional value. And then separately, the concern that even with equality, we want a sense of real civic orientation in our leaders and a sense of the public interest. And both of those are extraordinarily important values that any court up until the recent one would have said easily outweighed this sort of alleged speech interest.
I would just say simply, whatever one man, one vote means, we don't have it with this campaign finance system.
I think one of the questions to push back on is I think thinking about equality in the abstract raises, I think, a lot of phantoms that maybe are not necessary. I mean, I think that one way in which you can think of this is a question of institutional context. What are elections? What are they for? I think that the current prevailing metaphor that the Supreme Court has adopted and that others have adopted is that elections should be thought of in the same way that we think of the overall marketplace, in which equality is presumptively not the value that we're talking about. Instead, we're talking about kind of lack of constraint, lack of regulation as being the baseline from which we're working. I think another way to think about that, and a number of legal scholars, I know Robert Post is working on a book about this right now, is can we think of elections as more of a deliberative institution? Like, we don't think of it as a First Amendment violation when both sides are given the same amount of time at oral argument, because we assume that the purpose of that oral argument is a deliberative purpose. And I think that if we are able to think about elections as being a purposive institution in the same way, a way in which we determine who will govern us, then that is one way that I think equality principles can be incorporated in without raising the overall, issues that it would raise in other contexts.
prior to the Federal Election Campaign Act, we basically, I mean, there were some laws on the books, but by and large, people could give and spend whatever they wanted to without regulation. And in that scenario, we passed the Voting Rights Act and the Civil Rights Act and Medicare and Medicaid and Social Security and created the Environmental Protection Agency and did a lot of very progressive legislation. Dollars are not stuffed into ballot boxes. They are used to speak to people, whether through commercials or through renting a hall and doing the staging for a speech or what have you. So in that respect, you know, the court is quite right in saying that spending money is intricately bound up in your First Amendment right to speak. And this idea that this offends one person, one vote is very different. One person, one vote is, in the end, each of us as a voter makes a decision. And to actively use that, we have to actually hear a variety of voices. And this was the concern Douglas raises in the United Auto Workers case. And we look at it now, you know, poor people don't have the money, by and large, to speak. They need wealthy champions. And by and large, they have them in our society. The big dollar individual money and big dollar corporate money is not flowing solely to Republicans. It flows in many ways across the political spectrum, and there are big financial angels on the left who empower people who otherwise could not be heard. Even in the Republican primaries this year, Rick Santorum and Foster Friess, Newt Gingrich's supporters were much lower income people on average than were Mitt Romney's supporters, and the super PACs made them heard, these PACs funded by people like Foster Friess. So we need to think seriously about how money works in politics, that money, you know, can give some people the sense that they're being drowned out, but it can also make a lot of people heard. And I don't think the one person, one vote analogy really holds up in that context.
Larry, you wanted to speak?
No, it's-
Okay, well, you know what? Then we're going to leave it there. But before you applaud and turn on your phones and so on, I just want to read this announcement about the breakout sessions that will follow this program. There are 4 of them. Number 1, what's at stake? Examining voting rights in the 21st century, and that's in the federal room. Number 2, after oral arguments, the Supreme Court and the Affordable Care Act in the congressional room. Number 3, the view from the bench, judicial campaigns, and public confidence in the courts, and that's in the South American room. And then this 4th one is quite long, and it says, congressional gridlock and the executive, a battle over nominations, recess appointments, and the use of the filibuster in the Senate room. Please also join us, where else? Please join us also for the closing plenary, which is the resegregation of America, race, and the Roberts Court. Brad Smith is not on that panel. In the presidential ballroom at 1:15 p.m., volunteers will be on site to help direct you to these locations. This has been a joy and a real honor for me, and thank you, panel.